Well, welcome everyone. Welcome to this live stream session. I am Lior Samfiru, the employment lawyer, and you're here to learn and understand employment law. That's why you're here. That's why I'm here to tell you what you need about employment law. This is a live Q&A session where you get to ask me all kinds of questions about your workplace rights, your rights at your job, your employer's conduct. All those questions you can ask me and I'll tell you, I'll answer, I'll give you the information that you need to have. Again, if you're wondering how you stumbled on this, who I am, I'm Lior Samfiru, one of the founding partners of Samfiru Tumarkin LLP. My firm, you can find us in Ontario, BC, and Alberta. And if you have a workplace issue, we've got your back. And one of the things you can do right now is ask questions right now. Maybe it's a wrongful dismissal. You lost your job. You're wondering, is this even legal? Can they do this to me? What do I do in return? What am I owed? Ask the question. Maybe it's a situation where something has changed and you don't know if it's legal. They changed my hour, my commission structure, my pay. Can they do this? What should I do? Ask the question. Of course, if it's a situation dealing with not being treated properly, a lot of people contact me because they feel they're being bullied or harassed in the workplace. Well, if you need to know what this all means and what you can do, just ask the question. I'm live here with you for the next 30 minutes for the sole purpose of informing you and educating you on your workplace rights. There's no bad questions, okay? There's only answers. There's only solutions. There's only things that you can do because the law is quite good. So if you want to know what the law is, workplace rights, employment law, ask the question. Again, I'm Lior Samfiru with Samfiru Tumarkin. And before I start answering questions, let me give you another amazing resource you can always go to. If you want to connect with me and my team off social media, have a private discussion or an email exchange, all you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the bottom of the screen there. When you're there, as I said, you can get all the contact information you can ever need, but you can also read a lot more about your workplace rights, about employment law. It's your one-stop resource for anything and everything employment law. But right now, you don't even have to worry about that because I'm with you live right now. Lots of questions over the past few weeks on these sessions. I want even more questions today. Let's beat that. Let's keep me on my toes and let's keep me busy. So ask your question if you're wondering anything about employment law. I'm going to start answering questions, and as you're listening to my answers and the questions, ask yours as well, okay? Lots of time for you to do that, so get asking. All right, let's see. First question with me, Lior Samfiru, the employment lawyer. It comes to us from YouTube, and this is from Phoenix. I've been working with my current employer for 3 years. We were recently told that they're closing and a new company would absorb all employees. The new company issued contracts, and all job titles and duties are being changed. Our benefits and vacation time is being decreased. We have 5 days to sign, and I'm not sure what rights I have in this situation. So if you're offered a position that's different, significantly different in terms of responsibilities, pay, hours, etc., you may not have to accept it. And if you don't accept it, you're owed full severance from the company that's selling the business. Now, you don't have the ability to force the new company to change things. You can certainly ask, you can negotiate, but ultimately, if they say, no, this is the deal, take it or leave it, if what they're offering you is very different than what you had, you then may be able to say, I'm not taking it, and you're still not losing your severance. So you've been with the previous company for 3 years. Now, I don't know exactly the job you were doing or your age, but you could easily be owed as much as 6 months' pay, maybe even more, of severance. So the key is how different is what the new company is offering in comparison with what you have now with the present company. If it's a minor change and you say no, you may not get your full severance. But if it's very different, yes, you may be able to say not accepting it and get severance. So what do you do now? It's very easy. I want you to connect with me off air. And when you do that, I want to see the offer, the new offer. I want to compare that with what you currently have. And then I'll be able to tell you, do you have to accept, do you not? How much severance do you get? Who do you get it from, etc. So very important, because whenever there's a sale of a business, you may not have to accept the offer with the buyer. You may be able to say, forget that. I just want my severance and to go somewhere else. Ever if you're facing a sale of a business situation, let's talk about it. Certainly do not sign, Phoenix, do not sign anything without seeing me first. Potentially by signing that agreement, you could be giving up rights. Don't do that. So Phoenix, to connect with me and my team off air, so very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. Got your back, and you can connect with me that way. Thank you. Fantastic question. This can be tricky with the sale of a business, so I'm glad Phoenix asked the question. If you just joined us, if you just kind of stumbled on here, welcome. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you're here in my live stream employment law session. This is where you get to ask questions about employment law, about workplace rights, to know what you need. If you're working, if your boss is not treating you properly, if you're curious about your rights, ask the question right now. I see questions coming in. I'm going to answer them immediately, but you have time, so much time, in fact. Take your time, ask the question, get the answers. All right, let's see our next question. And this one comes to us from Mike, who's also on YouTube. I was moved to another department against my will. This reduced my commissions by more than 20%. I complained, and they fired me a week later. Is this a reprisal? It may be a reprisal for sure, because your employer may not have a right to reduce your pay, and if you complain about that and you get fired, that could be a reprisal. But there's a different issue beyond even that, because it may or may not be a reprisal. But what we do need to know is, did they pay you proper severance? I don't know anything about this company, but a company that would treat an employee like that probably are not paying proper severance. Now, Mike, you haven't told me how long you've worked for the company, what kind of a job you were doing. You haven't told me your age, so I cannot assess the severance that you're owed. But I can almost guarantee you that whatever it is you're actually owed is more than what the company has offered you. So we need to discuss that, yes, and potentially reprisal. For those wondering, reprisal is simply a situation where you get punished or fired for standing up for your rights. It's illegal, okay? You cannot be fired for enforcing rights that you have. So you need to call me, Mike, off air. Let's do that as soon as possible. You can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. And Mike, when you do that, I'll help you get whatever compensation that you're owed. I may not be able to get your job back, but I can definitely help you make sure you get the compensation that you're owed, and that could be quite substantial. Now, I told Mike that I don't have the information I need to assess what he's owed. Well, how can Mike find out what he's owed? How can you find out how much severance you're owed if you lost your job, if you're worried about losing your job, or if you just want to know how much severance you're owed? How do you do that? Easy. All you do is you go to pocketemploymentlawyer.ca. You see that address on the screen right now, pocketemploymentlawyer.ca. When you're there, just click on the severance calculator. That's it. Severance calculator calculates your severance. And when you're there, you can find out in just seconds how much severance you're owed. You answer 3 questions: your age, your position, and the length of your employment, and you get an assessment of what the law says you should have. Spoiler alert. It's not a week per year. It's not 2 weeks per year. It's a heck of a lot more, okay? So check it out. Completely free, by the way. Completely anonymous. No names, no strings attached, no credit cards. Again, pocketemploymentlawyer.ca. Click on the severance calculator. And if you want, you can even contact me directly from that. Over 2 million people have used it. Be one of them. Make sure you understand your rights. So Mike, you can do that. Anyone else here can do that. It's completely free, completely anonymous. But right now, oh gosh, love it. More questions are coming in. I'm going to continue answering them. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And let's get some more questions answered right here, right now, and ask yours as well. Don't be bashful. Lily has our next question on Facebook. What can you do if your employer lets you go while you're preparing to go on sick leave? So what you cannot necessarily do is stop your employer, but a few things. If they're letting you go because of that, so if you told them you're going to go off on a disability leave, a sick leave, and they let you go, if that's why they let you go, you could be owed human rights damages. It's illegal. It's a human rights violation to let someone go because they have a serious medical condition. You can't do that. So right off the bat, you're owed compensation. But there's something else. Even if that's not why they're letting you go, If you have a medical condition, now you're not going to be able to work. That means they have to pay you enhanced severance, because you're not going to be able to just go and look for another job. You're going to go off on sick leave. So if you're going to be out of commission for a while, forget about the usual severance that they would have to pay you, which would be quite a lot anyway. They're going to have to pay you even more severance than that, enhanced severance. So that's what you can do. Make sure you get compensated. Now, there's even a chance potentially we could get your job back. Oftentimes when a company hears from me, maybe they want to take the person back. But either way, Lily, it starts by reaching out to me and my team as soon as possible. Don't wait on this, okay? It's illegal to let someone go because they are sick, and you're going to be owed enhanced severance as well. You want to reach out to me as soon as possible through employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that great question. Waiting to hear from you, Lily. Don't be bashful. All right, more questions coming in. Let's answer them right now. Next one is from Joanna. Joanna says, does that mean that I only have 1 year of severance calculations, even though I have worked there for 25 years? Sorry, I missed that. Joanna first says, every May I sign a contract. I sign a contract that is for September to the end of June. I work in a school. I'm laid off for Christmas, holidays, March break, and summer. Does that mean I only have 1 year of severance? No, absolutely not. So because you've been doing this every year, it becomes a regular thing, Joanna. The law says you are now a regular employee, okay? A regular employee. Those contracts that you sign become meaningless. Now, the first couple of contracts, that may be different, but if you've been doing this now for 25 years, you are a regular employee. So what does that mean? That means if your employer decides to let you go, they're going to have to pay you severance as a 25-year employee. That means you could be owed as much as 24 months severance. 24 months is the maximum for most people. In some cases, you could get more, but for most people, it's 24 months. And for you, after 25 years, you could easily be owed that maximum, Joanna. So what I need you to know is if you lose that job, yes, you're going to be owed your full severance, regardless of what that contract says. For now, continue working. If and when your position comes to an end, you call me right away, okay? I'll make sure you get your full severance. Your employer is not going to pay you proper severance because they're not going to know that they have to. That's why I get involved. We educate them. We get you what you're owed. So this is actually a very important and common situation where you sign a new contract every year. Well, what does that mean? No, you're not. Once you go beyond 3 or so contracts, the law says, forget it. Those contracts are meaningless. You look like a regular employee. You act like a regular employee. So you're a regular employee. It doesn't matter what you sign. So that's how that works, Joanna. Any follow-up, still here. Don't be bashful. Let's make sure we get those questions answered. If you've just joined us, welcome. I'm Lior Samfiru, the employment lawyer, and I'm here answering questions about employment law, workplace rights, tell you what you need to know. Questions have still come in. More are on the way. I'm answering them. You still have so much time to ask yours as well. So take that opportunity and ask the question. Let's see. BC Pinoy has our next question. Sorry. Well, yeah, I'll take that. And I skip one, but I'll come back to it. BC Pinoy says, my wife's employer found out that they are overpaying her for the last 3 years. My question is, does the employer have the right to recuperate the 3 years overpaid? So realistically, the answer is no. If your wife didn't know that she was being overpaid and she took the payment and she spent it in good faith, they don't have the ability to recover that, okay? But if she says, no, I'm not doing that, that may cause conflict with her employer. So she has to decide ultimately, is she okay with that conflict? Or would she prefer to work out some sort of a payment plan when she pays a little small amount over time? She doesn't have to. But I expect that if she says to her employer, not doing it, they're not going to be happy and that may cause conflict. So legally, the answer is no, she probably doesn't have to. Practically, she has to decide if that's worth it to her and how she wants to handle it. If they give her a hard time, if they take payment without her permission, which they're not allowed to do, by the way, have her call me, okay? As soon as possible at that situation to call me, employmentlawyer.ca, again, employmentlawyer.ca, to have all my contact information, my team's contact information, Alberta, Ontario, BC, etc. All right, fantastic question. Thank you for that follow-ups. I'm still here. Let's see. Next question is from Last Dropper 33. Employer wants to move me to a new position. I've been a manager for the last 6 years, and this is not a management position. Can they just do this? So, we would refer to this, of course, as a demotion. So if you're a manager and they want to put you in a position that's not managerial, well, that's a demotion. So no, they don't actually have a right to do that. But the fact that I say that they don't have a right to do it does not mean that you can physically stop them from doing that. What it means is that if they do it anyway, say, we don't care, we're doing it, too bad, you're starting Monday, you then would have potentially the option to consider that a constructive dismissal. In other words, because they demoted you, because they changed the terms of your employment in a significant way, you may be able to consider your employment as being terminated and force them to pay you your full severance. So the remedy when your employer does something that they're not allowed to is to potentially treat that as a constructive dismissal. So again, sometimes people think, well, they're not allowed to, so let's stop them. You can't physically stop them. You can respond to it maybe by considering it a constructive dismissal. Before you do that, before you respond to them, before you say anything, let's talk. I want you to connect with me. I want to understand exactly how the demotion is going to affect you. Is it just a responsibility? Is there pay reduction involved? How much notice did you have? Any notice? All those things may change the analysis or may make the case better, less strong, etc. So we do need to have that discussion. So Last Dropper 33, you know what to do. Connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. Let's have that discussion. Again, if you've just joined us, I'm Lior Samfiru, the employment lawyer, live here answering your questions about employment law. There's a little box on the screen. You can type in your question, hit enter. It's going to pop up on my screen. I'll read it and I'll answer it. It's that simple. It doesn't take any more effort than that. So ask your question, just like so many people are doing right now. I'm going to continue answering questions. Let's see. Giovanni has our next question. Giovanni says, I quit my job as a custodian at a school. I asked my employer for a resignation in paper, but she refuses to cooperate. Does she have to provide me with the paper? I'm not sure what paper you mean. If you resign, you resign. They don't owe you anything other than your record of employment. So I'm not sure, Giovanni, to what paper, what resignation paper. If you want to give them a resignation letter, you can. You don't have to. But if you resign, you simply resign. All right, let's see. Next question is from Shafi. Does low vision or not being able to see properly due to age make you eligible for disability? And if you have a medical report to support that. So yeah, what makes you eligible for disability plan is, number one, to have a disability plan. If you have a disability plan, short-term or long-term disability through work, then you can qualify for that if you cannot do your job. So the question is not, how does low vision impact it? The question is, because of the low vision, can you do your job or can you not? If you can do your job, maybe it's a bit harder, etc., but you can do it, then you don't qualify. If your doctor says you cannot do your job now anymore because of your bad vision, then you absolutely qualify for disability benefits, okay? But again, you have to have a disability plan through the work. So ultimately, to qualify under a disability plan, it comes down to what your doctor says. If your doctor says you can't do your job anymore, regardless of what the medical condition is, it could be low vision, it could be a bad back, it could be depression. If you cannot do your job anymore, then you qualify. If you're able to work, then no, you won't qualify. So the question ultimately is, you have to talk to your doctor and ask your doctor, here, can I do my job? Here's my situation. If your doctor says no and it gives you a note, no problem, you qualify. And last point I'll make this. If your insurance company gives you a hard time about qualifying for disability, contact me as soon as possible, okay? We have a whole team dealing exclusively with these disability issues, and we make sure that the insurance company pays you what they're supposed to pay you. So you can connect with me and my team. I'll connect you that way, and easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic questions today, guys. Love the questions. By the way, we still have time. You still have time to ask your question right now, so don't wait until the very end. and then ask the question, because I may not be able to get to it. Right now, if you ask the question, I promise you I'll get to it and I'll answer it. So let's continue answering questions right now, and let's make sure everyone has the answers that they need. BD22 has our next question. My partner was let go from his position after 10 years. They gave him 6 weeks. It was deposited into his account with his last pay. Is accepting the money like agreeing to the termination? Well, by accepting the money, you're not agreeing to anything. Keep in mind, you don't need to agree to the termination. An employer is allowed to terminate you. You don't want to agree to the severance that they've paid you. But if by taking the money, you're not agreeing. The only way you can agree is signing something. So no, there's no issue. Now, I can tell you right now that after 10 years, he's going to be owed a heck of a lot more than 6 weeks. He could be owed 12 months pay. It could even be more than that, depending on his age and the job that he was doing. So probably somewhere between 12 months or more. He needs to call me ASAP, today, okay? I wouldn't wait on this, okay? If he's owed a year's pay, why wait? Why would anyone want to wait in that situation? Have him connect with me as soon as possible. Employmentlawyer.ca has phone numbers, email addresses, faxes if you prefer, forms to fill out, whatever you want, and every way to contact is right there at employmentlawyer.ca. So don't worry about the fact that money was deposited. He can use that money. He's just owed a lot more than that, okay? A lot more than that. So have him connect with me through employmentlawyer.ca. All right. Love the questions, guys. I'm going to continue answering. Let's not stop now. JX2 has our next question. A coworker of mine was dismissed a while back, has recently been rehired. Can that past offense be used against them to claim justifiable termination in the future? No, absolutely not. And by the way, there's no such thing as justifiable termination. An employer is allowed to terminate for any reason, justified or not. They can let someone go because it's Wednesday and they feel like it, as long as they pay severance. So no, the past history is not going to affect his entitlements to severance. But the one thing that it's interesting is if they let him go down the road, the time he had previously may actually count towards his seniority, meaning he's owed more severance. So if you work for a company, but your work has not been consecutive, in other words, you had a gap in employment, you worked for a time, you left, then you came back, it's quite likely that all your time combined is going to count towards your severance, which is good, of course. The more seniority you have, the more severance you're owed. You may have had 4 years, then you took a break for a couple of years, and you came back for 5 years. So you actually may be now a 9-year employee, despite having a gap. And if you're let go, you should be getting severance as a 9-year employee. So that's how that works, JX2. Don't worry about justifiable termination. An employer can let you go. It's a question of severance. Of course, to connect with me and my team, very easy to do, employmentlawyer.ca, the place to go to. Fantastic. Let's see. Next question from Peter. If I get on short-term disability, am I able to look or leave the job I'm on because of unsafe workplace condition? 90% of our staff has been fired and replaced since January. Would one even have a case for severance? Yes. First of all, you may absolutely have a case for severance. If you can show that your workplace was unsafe, it's easy actually to get severance. Can you look for another job? Absolutely, you can. Not an issue. And if you find another job, you want to take it, you can absolutely quit. Obviously, if you're going to work for another position, if you're going to get another job and start working, you're not going to get disability benefits because you're going to be working. So there's no issue. You can look for another job and take another job. But yeah, you actually may be owed severance. So before you do that, Peter, let's talk. Okay, I want to understand exactly how the workplace was unsafe, who knew about it, what you said or did about it, because yeah, you may absolutely be owed severance. So let's make sure you get that severance. And Jay, so Peter, that's what you do here. Let's make sure that you connect with me now. Don't wait on this, okay? Don't wait until you find the job. Let's connect now. Again, employmentlawyer.ca, employmentlawyer.ca, the way to do that. See, JX had a follow-up question. He was talking about a coworker that left and got rehired. I believe he originally started around 2010, was dismissed about a year ago. He was back with the company for at least a couple of weeks. So the time that he spent between 2010 until he was let go last year counts towards his severance. So if he's let go now, that 13 years counts. So he's not a one-year employee. He is now an employee with 13 or 14 years of seniority. Very important, okay? And so if he's let go, man, oh man, does he need to contact me right away. Employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's take one more question here today, and that is from Kona. Kona says, I took a second job recently to make ends meet. I let my primary job know about this and what my schedule would look like. I had planned things out so that there wouldn't be an overlap. Now my original employer is changing my schedule so that my shifts overlap and said, deal with it. I feel that they're doing this job to force me to quit my other job. What can I do? So the question here, Kona, is in the past, have they changed your schedule? Or has your schedule always been fixed? If your schedule has always been fixed, and now for the first time they wanted to change it, well, that could be a constructive dismissal. You may be able to treat this as a termination and get severance. You can't make them stop, but you can get severance. On the other hand, if in the past they've changed your schedule and there's a regular thing that they change your schedule and they're doing it now, then there's nothing you can do about it because there's a term of employment that's been created over the years that they can just change your schedule. And if now you don't like it, then there's not much that you can do. So the question is this something that they've done before or is it the first time? If it's the first time, potentially constructive dismissal. If they've done it before, probably not much that you can do. You can connect with me, Kona, so we can discuss this. And if it is a constructive dismissal so that I can help you pursue it, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. That's how easy it is to do it. Guys, I think this is a good time to stop for today. Fantastic questions. You guys always keep me on my toes, always give me interesting things to consider and talk about. I really appreciate it. Always a pleasure to be here. I'll be back next week, but don't wait until then. If you need me and my team, we're here, okay? Just go to employmentlawyer.ca and we can connect now. You don't need to wait to see me on live stream a week from now. You can connect with me today, all right? Employmentlawyer.ca is the way to do that. I'm Lior Samfiru, the employment lawyer. If you didn't get your question answered, go to employmentlawyer.ca, connect with me. There's plenty of answers and opportunities to get help and solutions. Thank you, guys. Again, Lior Samfiru with Samfiru Tumarkin LLP. We'll see you again soon. Thank you. Bye now.